then the order of ceremonies is basically the complainant gives their side of the story, the respondent gives their side of the story. Then the complainant has a right to re-examine, the complainant gives their side of the story, the respondent has the right to cross-examine their side, their witnesses. If they do cross-examine, the complainant may want to re-cross-examine the cross-examination, but it always ends with the respondent having the final say. Then, once all the complaint is finished and dealt with, it reverses. The respondent then presents their evidence, cross-examined by the complainant, re-cross-examination by the respondent. If the claimant again wants to re-cross-examine, it returns again for the respondent, so the respondent always has the final say. So that's basically the way that it proceeds, or should proceed. So the next thing then is the grounds for appeal is anything which prejudices your defense. Okay? So that there basically is an error of law, which is any procedural error, or that the decision could not have rationally been reached based upon the evidence before the court. And also, if there is new evidence which becomes available. So now there's different ways of appealing. Section 142. This is the magistrate's court where it has the opportunity, when put with information, that there's been an injustice. So you give a detail of what happened and why you felt it was an injustice, to give the court the opportunity to correct that injustice, so they can reopen the case and deal with it with your appeal. There is not a statute of limitations on this. So this can be done at any time that an injustice is found. So that's section 142. Now with all the council tax stuff, we need to put together the section 142s and ask them to reopen the case based upon the new evidence that we've got, which points out that it's an injustice that's occurred. Then, if you want to go straight to the Crown Court, section 108 allows you to go to the Crown Court. Now, depending on how you pled, okay, you can appeal either just the conviction or just the sentence or both. So if you pled guilty, okay, you pled guilty to the conviction, therefore you can only appeal the sentence. So depending on how you pled does affect your rights of appeal, your legal rights to appeal, okay? So duress means you can appeal everything. So they threaten me with a longer jail sentence unless okay? That means you can then change your plea. So part 34 of the criminal procedure rules, that there describes how to appeal the criminal process. Now, the one that we're starting to use is this next one, section 111, by statement of case, where what we're asking is, how based upon the evidence did you reach your decision in law or in fact for the opinion of the High Court? Okay, so what this means is the magistrate's court must prepare the statement of case for the High Court. And we've had very interesting results with this. All right. So in Liverpool, when we section 111 them, basically they turned around and said, we don't accept your application for section 111 appeal because it's not in the format as prescribed in the rules. Okay? And now you're out of time. So we turned around and said to them and said, it appears that you're not clearly understanding the Magistrates Court, your obligations under the Magistrates Court Act and under the rules section da-di-da, because guess what? the piece you copied and pasted is what you meant to give to me in 21 days. You have to prepare a statement of case. Okay? They've never, ever been asked to prepare a statement of case before in Liverpool. Or if they did, the last time they did it, the people are dead. Okay? But this again highlights the problem, the absolute ignorance. This is from Liverpool Magistrates Court, judicial officers, you know, the advisors. Right? And so the next sentence was, I suggest you go and get some legal advice. But this is the level of the problem that we face. Okay? It's ignorance. And so what should happen is, you ask them the questions, they then must prepare the statement of case. You then have 21 days to ask them to change it if you're not happy with it. They then must redraft it to you, and then you go with that to the High Court to get the appeal dealt with. So, so that applies to both civil and criminal. Right. So that's all that I want to talk about on the magistrates' courts at the moment. I want to talk a bit more specifically, and we'll get to the civil procedure rules and certain criminal procedure rules which may be appropriate or the most relevant that you may come across. Okay, now the rest of the courts I don't want to go into much detail. I've actually written a bit about on the county courts, but really until people are familiar with the basics, okay? At a later point, we can start to fill in more details. Now, the county court, the legislative confirmation is County Courts Act 1984, and Section 23 grants it limited equitable jurisdiction. Okay. However, guess what? Earl of Oxford case says you must deal with everything under the laws of equity. So it has full equitable jurisdiction. Okay, it only deals with civil matters, and we'll be looking at the different types of categories of civil matters. And essentially, it is given a financial limit. The magistrates' court basically, in theory, can deal with up to £5,000, something like that. Then the money claims up to £10,000, and then it keeps going up. So depending on the value and complexity, it works. Right. The first thing really that happens with all cases is case management. So it doesn't matter which court you go to, the first job of the court is either a case management hearing or a pre-trial. There may be other words they use for it, I can't think of it off the top of my head. What they need to do is establish that the parties have all the information from one another. And so what happens with the case management is each party says, I need from the other this and this and this, and I need this from them. The court then makes an order and says, you give them that by then, and you give that to them by then. So that what happens is they then list it for a trial, and in the trial you're not arguing, oh, but they didn't give me this or they didn't give me that. Okay? So a pre-trial hearing or a case management hearing is to sort out and get the case ready before it goes to trial. And essentially that's all about full disclosure.
So Mark, what happens with, like in my case, the court is not even involved?
How do you mean?
Well, I've gone up there, I've asked them for the court case number.
Yeah.
There's not one. I'm not
For council tax?
No, this is my case in the Wimbledon Magistrates Court.
Yeah.
So there's no case. They're saying to me that the court has got no record of it in the legal system. So they told me to go and see the CPS, who is the claimant.
Yeah.
When we turned up in court on Friday,
Yeah.
I asked them again for the court case number, and they're telling me that the URN number, which I was given in the police station, is the court
No.
case number.
If there is no case number, there is no matter before the court. There's no case.
So I'm asking them, who brought the claim to the court and who paid the fee? I want a copy of the receipt.
Okay, basically, if the court has not allocated a case number, there is no matter before the court.
That's what's going on.
Do that with
You
council.
know, they do with the council tax. Okay, but they do with this stuff pretty much the same thing. Right? What happens with council tax is they come in with a list of 2,000 names and 2,000 claims, basically. Of that, say 10% of the people will attend the court. And then of those 10% that turn up at court, 90% of those will cut a deal because they offer you a special discount, i.e. they entrap you into contract, into an obligation. And 1% will end up wanting to see the judge and argue their case. Of those 1%, they'll decide, okay, hang on, 90% of them, essentially, they'll railroad, and 1% they will adjourn. The awkward buggers, okay? So literally, out of 1,000 people, possibly one will be adjourned. So what they do is, they take the 90%, they get a default judgment on the 90%. They remove the 90% of the 10% who have contracted now. Of those which were before the judge, they now remove the one for an adjournment. And then that there gets rubber stamped and a case number gets put on top of it. It should work the other way around.
I went to approve the council tax hearing, and he made the liability order.
Yeah. Oh, and said, what reasonable excuse have you got for us to set it aside?
Yeah, basically.
Yeah. Okay, the way, all right, so the council tax.
But no, the thing is, I want to say is, he made the liability order, and then he said I could appeal, but I still have to pay the council tax.
Yeah. Because
So-
an order of the court, once an order of the court is made, until it's changed, it's the law.
Even though I'm appealing.
Yeah.
So they can.
Yeah. Okay, so what did they do with mine? Basically, I put in all my notices, and then when I went to court, we got there at 10 to 10. At 10 o'clock it was listed, we checked in with the clerk. Ahmed and I went to the clerk and said, yeah, for council tax. And then about 10:15, there still was no sort of stuff going on or anything. So Ahmed and I decided we're going to go into the public gallery and just sit and watch what's going on until something happens. So they refused us access to the public gallery. So we basically, in front of the court, doors, started making sure that the public heard what we were saying. Right, security guard, who the hell are you to deny me as a member of the public access to the court? Okay, what's your name? What's your ID? Everything's hidden. I'm going to call the security. Don't waste your time calling the security, call the court manager. And with all this, and we pulled out the page on open justice and read the law to her. Said, get the court manager here. The usher then came out from the court. What's going on out here? And so we said, can we just put this flipping security guard right? They've got no right to deny public access. We've even told them the law and they're still denying public access. Usher says to them, you've got no right to stop anybody coming in. In we go. There was a person there already, and the court said to him, the court has made a liability order against you. What reasonable excuse do you have to ask for it to be set aside? Okay? Anyway, when they finished with that one, next was us. Ahmed and I walked in, and the clerk was straight away, Ahmed, in the public gallery. So quite simply, are these from the council? Yeah. Are either of them officers of the court? No. Well, thank you, the court set precedent, you don't need it, come on up and let's go. So in we went, because they'd set the precedent. They do not have officers of the court, and what they've said is, I don't need officers in the court to speak. Okay, and in your case,
She said it
they
was.
actually lied.
Yeah.
She lied and said, yes, one of them is an officer of the court. Okay? So that means, in theory, if they've got no legal representation, you can have a Mackenzie friend with rights of audience. You don't need to ask why, because the court's already set a precedent in this hearing. Okay? And so then they ask, you know, what reason have you got to, that we need to set aside the liability order? I said, huh? I've been here the whole time. The liability order is void if you've made one, because I've been here and you've not shown me the evidence. I've not had the right to defend myself against the evidence. I've not had the right to cross-examine the evidence. So how the hell have you made a liability order? Oh no, you weren't here. So anyway, that ended up into a battle. I just turned around and eventually said, are you calling me a liar? Because I'll go now and get witnesses in here, as many as you want, that I was here before 10 o'clock. You had no lawful excuse to proceed. And by the way, what is the case number? Oh, sorry, you had no lawful excuse to proceed, and therefore, it's not a matter of setting aside any order if you've made one. Whatever you've done is void because of abuse of process. So then I asked for the case number, and they said they've got no case number. I said, so therefore, thanks. You've admitted that your due process has not been done, but even worse, there's not even a case before the magistrate's court. So how the hell have you made this liability order? And then they were like, well, what's your sort of story? So we pulled out the Bill of Rights and all of this sort of stuff, and the clerk of the court starts with, Lord, freeman of the land. He said, no, this is all current legislation, mate. So he sort of quickly turned to the bench and said, my advice is we adjourn this matter and set aside the order. I said, no, it doesn't get set aside. It's void. There is no order. Okay? And so basically then I said to them, I want an order from the court that the council must answer my questions. And they gave me the order that I wanted.
How could they proceed without a case number?
They can't.
So how did they manage to carry on?
Because what they
They're
normally
criminals.
do is nobody challenges it, therefore they do what they do, and they, if nobody's got a problem with it, those who don't stand on their rights up, no, they do what the hell they do.
But isn't it fraud to represent that there's a case going on when they haven't got a case number?
Yeah, but, okay, what should happen? Okay, they put in their list, it gets given a case number. Okay, then from that, they may be claiming 2,000 orders. They then need to withdraw and adjourn or whatever, take out who's paid or who they've reached contract with. But it's got the case number in the beginning.
Okay.
But what they do is, I don't know why, it makes no difference. I can't see how it makes any difference with the paperwork. They just put the case number at the end. I don't know.
When we challenged them with that, it was Carrie. I can't remember her surname now. She asked that when she was in the court, and they responded that it was the number that was on our summons.
That's bullshit. That's a lie. That's fraudulent misrepresentation. But anyway, all of these things we're documenting now.
Yeah.
Okay. Okay, the county court is, the criminal procedure rules apply to all courts. Okay? The civil procedure rules apply from the county court up. And then there are a few specialist rules for the Supreme Court. Okay? So, now, the civil procedure rules are your friend. You don't need to know many of them, and there's some extremely powerful ones on them. And we'll look at those, because it's really about forcing disclosure. But the links basically are in the manual. The family courts are to deal with family matters. The same cost rules apply in all of the courts. there's some specific family court rules in regards to basically anonymity, i.e. that children's names don't get put into public and reporting, stuff like that, to protect privacy, which you can sit and argue whether that's fair and just, but that's another matter. Appeals from the family court go to the High Court. Right, the senior courts are basically the county court, Crown Court, High Court and Appeal Court. And equity applies in all of those. They're covered by the Senior Courts Act 1981, and Section 49 makes it a legal obligation to apply the rules of equity in every matter before the court, before those three courts. Okay? So this is a partial codification of the Earl of Oxford case. So it's a legal obligation to apply the rules of equity in these three courts. Only in these three courts. And this is why, if you want to force the court into equity in any other court, you need to use the common law precedent which binds the lower courts. You can't say, in accordance with the Senior Courts Act, if it's not a senior court. There is no legal obligation for the other courts to use the rules of equity, but you force them, you move the court through the Earl of Oxford case, 1615. Okay?
Can you use a lower precedent in the higher court?
Cool, mate.
Sorry?
Can you use a lower precedent in the higher court?
No. A higher court is
So
not
if
bound
I'm
by a
trying
lower
to,
court.
what I'm saying is, if I'm trying to make a, I don't know, for whatever reason it fails and it goes up to a higher court,
Yeah.
can I use a precedent in a higher court or not? If you understand what I'm trying to say.
What, equity?
Yeah, just in terms of any case precedent. So say, for instance, I don't know, I go to the appeal court, and the appeal court wants to go to the Supreme Court.
Yeah.
And I go from magistrate up to appeal. And in appeal, I've got a crown,
No, the higher court is not bound by a lower court's decision.
decision, it's not.
No, it's the other way around. Lower courts are bound by higher courts' decisions.
Can you move a magistrate court case into equity?
Yeah,
Simply by
you
quoting
force
the-
them into equity using the Earl of Oxford
Can you
case.
just quote that and say, I move this court into equity?
No, in this particular thing, the court must apply the rules of equity under its obligation, lawful obligation, to follow the Earl of Oxford case 1615,
Right.
because the existing law, common law that they're quoting, is not fair and just, and equity is invoked by anything which is unconscionable, and therefore you're arguing lawful excuse. Yeah, Nick?
Can you not force the courts up a level for just appeal?
Sorry?
Or just lodging an appeal, it goes to higher court, goes to a county court?
Yeah, no, but what the question was, if I've got a lower court judgment, is the higher court bound by it?
No.
No, correct, yeah. That was what he was asking. Yeah. Okay, so the Crown Court basically deals with more serious criminal matters, like murder, rape and robbery. It's trial by jury. They deal with appeals from the magistrates' court. Same thing applies with costs, so long as you follow your due process, you act in honour, good faith and clean hands, okay, then same thing, equitable costs apply. The Crown Court rules, basically, they follow, like I said, criminal procedure rules are for everything, and the civil procedure rules apply to everything except for the magistrate and the High Court. The Supreme Court. Essentially, appeals, okay, is anything on points of law, excess jurisdiction. Quite simply, what does that mean? If a decision cannot be rationally based upon the evidence before the court, that's an excess of jurisdiction. Okay? Because the jurisdiction, the authority is only to consider the evidence proven before the court. And if there's a misapplication of the law, or the law is not clear, you can argue points of law. So anything simply which prejudices one party or the other. The equivalent of an opinion for the High Court from the Crown Court is under Section 28, as opposed to in the Magistrates Court, Section 111. The same thing, the Crown Court must prepare the statement of case for your approval, you review it, they need to correct it, back to you, and then you take it to the High Court and ask them to evaluate, give you an answer. So that's the same procedure. Now, if they refuse to state a case, and we've had this now on a number of cases, if they refuse to state a case, i.e. how did you reach this decision? But now we actually hopefully start to force them in the courts to explain their decision rather than after the fact. Okay, if they refuse to state a case, so we've had put in Section 111's, why are you denying me to choose my representative who I want to help me? Okay, they need to explain why they're refusing to state a case. If we don't like the answer they're giving, then we go to the High Court with that and ask for what's called the order mandamus. Upon whose authority, Mr. Magistrate? Who the hell do you think you are that you don't need to explain yourself? Okay? And to do that, you need a certificate of refusal to state a case. Okay, so that's the generalities of the court, what I'm going to talk about. But just to show you, people talk about this thing called, oh, everything's admiralty law and stuff like that. Okay? So these are different jurisdictions. Remember what we said jurisdiction meant. Okay? Jurisdiction is the authority to resolve the dispute before you. So, you've got planning courts, they deal with planning matters, administrative courts, general stuff, commercial courts, technology and construction courts, and what is that? Admiralty court. So if you think the admiralty law applies to you or the law of the sea applies to you, unless you're in that court, forget it, mate, it doesn't apply to you. Okay? Mercantile courts, intellectual property, patents, bankruptcy, general stuff. There are so many different types of courts, okay? But jurisdiction means, does the court where you are have the authority to resolve the dispute before it? It's not, I stand under common law jurisdiction, or I stand under equitable jurisdiction, or I don't stand under the law of the sea. You're just going to make an absolute idiot of yourself. What you need to do is try and help the judge and move the court to rule in your favour. So if you're standing there like an idiot, the judge is just going to get so frustrated with you. Okay? There's so many videos on the internet. Oh, common law is one. Okay, or birth certificate is one. Because the judge abandoned ship. Most of those, if you actually listen to the whole video, you'll hear the judge literally, he's going nuts. He doesn't want to lose his temper in the court. Because imagine the uproar if a judge starts screaming and shouting, you bloody idiot, what the hell are you on about? Okay, he's going to lose his job. So what they say is, adjourning for 10 minutes, so that he can go off and sit with a coffee and think, oh my God, another one of those idiots. Okay, recompose himself and come back in. And you actually can hear this. The judge saying, I'm adjourning for 10 minutes.
But why don't they just correct it? Because they never do.
Why don't they correct him?
I'm not saying it's right or wrong. What I'm saying is, why do they never correct? Why doesn't the judge,
Yeah.
who's supposed to be standing on whatever he's standing on, correct the individual to say this isn't a court of whatever, this is a X, Y, Z. Yeah, it's not legal advice, is it? If someone's making a claim, I'm guilty under common law jurisdiction, it's
Right.
a load of bollocks. Why don't you just put him right instead of saying, okay, I'm a journalist, see you later. And then walk away.
Look, quite simple, okay? You got people standing here. I'm the living man. For fuck's sake, I can see you're a living man. Guess what? A 5-year-old can even tell the difference whether you're a living man or a living woman. Yeah. For God's sake,
Well,
how
I've been in
stupid
court,
are
I've been in
people?
court where Victoria said to the judge, am I a woman? And he wouldn't answer. Does a woman...
It's self-evident
Well,
that
no,
you're a woman.
well,
What a
but why did you
stupid
just say,
question.
yes, you're a woman then? Just sit down.
He could have.
Well, he
Correct.
didn't. But she asked him again.
Yeah.
He said, I'm not playing these games. She
Yeah,
asked him
well, the
again.
transcript that I've read, I mean,
Bearing in mind that's been
you know,
doctored.
you can see from the transcript that the judge was getting really pissed off, and he was actually very, very patient in Victoria's case, from the transcript that I've got.
Yeah.
Okay? And at the end of the day, you know, everybody's got the tolerance level of how much shit they can take in a day, and if you've got idiots like this in front of you the whole time, it's self-evident if a 5-year-old can tell that you're a woman.
It's so easy for him
What,
to...
do you think I'm some idiot?
It'd be so easy for him to say,
It would be,
why don't you just say it?
correct, it would be.
1 in 4
I
times.
agree with you.
She even threatened her with contempt of court for asking the question.
Well, you know, with that, depending on the circumstances and what led up to it, okay? But,
I wish she'd have been there.
yeah,
It's like the Wild West.
no, it is. But I agree with you. Yes, you're a woman. Can we move on now?
Yeah, well,
Well, what's the problem with the judge saying that? I agree with
unless
you.
there is a problem with him saying that.
No, there isn't. Where?
Well, that's what I'm saying.
Where's their problem?
Well, why would he say that?
Hmm?
Why would he say
No,
it?
I have no idea. You think
It went on for, it went on for a long time.
Yeah, I know. But like, what I'm saying is, there is no problem with him saying it. It is self-evident. I'm a grown-up.
Well,
I can see
yeah, but-
woman, man. A 5-year-old
Maybe
can
there's
see
something we don't know
man,
about.
woman. There
But isn't-
isn't. If you
Well-
don't know about it, it's got nothing to do with you. It's unlawful if you don't know about it. There's been no meeting of the minds. Simply ask him. You know, why doesn't the guy
Bear in mind, he
answer?
wasn't under oath either.
Isn't
No, he is under oath.
We asked, are you under oath? He said, no.
Well, in that
She
case,
said, I've got your oath here. He said, take it away.
so if he said that, he's not
Then he's
acting under his
prejudicing you,
oath.
right?
But meanwhile, he had 4 armed police behind us.
It makes no difference.
But he did
If
to
he
me.
said,
He's scared of the daylight out of me.
if he said he's not acting under his oath, well, go and get a judge here who's here to do his job.
Well, she said, I'll give you I've got the oath here for you. She
No,
got it.
if he said, I'm not acting under my oath,
Yeah.
that there's end of.
Oh,
He's not a
Well,
judge.
we couldn't leave. He had us surrounded.
It makes no difference. If he said he's not under oath, automatically the decision's void.
Well, you would have hoped so. She's in prison
You are?
now. Well, you'd hope so, because she's in prison
No,
now.
it's simple. If
Yeah.
that is correct, and he said he's not acting under oath, nothing goes thereafter.
Well, you'd hope not, but...
Yeah,
meanwhile,
if she's got that-
He dragged her off with 4 armed police.
She's been back
Can
up
I-
ever since, mate. So what's happened to
Can
her?
I ask a question here
Yeah.
about this
What's happened to her?
business about the legal
Trying to get her
fiction
yeah.
and the living man or woman?
Yeah.
Okay,
That's fine.
so
They've said appeal, they won't give her the transcripts, point blank refused. And the
I've got a copy of the transcripts from.
They are
from it.
doctored beyond belief, mate.
Now the thing is, people need to be really careful, okay? Because if you guys put in a statement,
I said, it's my belief that this is not, I said, my belief, my belief, my belief.
yeah, okay.
Yeah.
Now,
I can tell you,
imagine that it actually is a transcript and your belief is wrong. That is going to really seriously damage it.
damage me or,
No, because if there's multiple people who claim the transcript's been doctored.
yeah, it's been.
Yeah.
I mean, what else do you do? They won't even give it. It's been a 1 year. She even went to the
No,
registrar.
I think Jackie, is it Jackie?
Yeah.
Somebody sent me the transcript. I've got
It's
a copy
taken-
of the transcript.
It's taken 1.5 years to get that.
Yeah, yeah.
And when it's arrived, I can tell you now, it's not how it went down.
Yeah, okay, but I'm just saying we need to be careful when we make accusations like that, because if we make it and all they do is produce the recording and say, hey, listen, mate, your belief is wrong.
Well, until we get the recording.
No, I agree. Yeah, yeah.
I
Yeah.
had a case.
Your thing's going all right.
Hang on.
Right.
Uh,
I had a case